So, very good evening, friends. Today we will be discussing a case study on individual insolvency. And I hope this study has already been shared in the group and you might have gone through this. So I would request Sandeep ji to please read the case study. Sandeep ji, please.
Yes, sir. John is a software professional working in an MNC. He has to travel worldwide in connection with his employment. His father-in-law is into business and has availed loan facility from PNB of rupees 250 lakh from the bank, for which John has executed a guarantee of rupees 250 lakhs. On default by his father-in-law, bank invoked the bank guarantee, which remained unpaid partly. As on the date of invocation of bank guarantee, rupees 25 lakhs were lying in the bank account, which were transferred to the account of PNB. Lily, wife of John is also a software professional working for an MNC. Various assets held by Lily and John are as under. 2 cars held by John and Lily primarily used for communicating to offers. 2 LIC policies on which loan facility has been availed to prepay the educational loan taken by John for his studies. 12 lakhs. He has created a private trust for the benefit of their children. John has approached you to take your advice in this regard.
Just a minute. Yes.
Question number 1. What is the worst thing that can happen in this regard? He may be declared bankrupt. His wife may be declared bankrupt. Both may be declared bankrupt. Any of the above.
He may be declared a bankrupt.
Sahi hai, Uma ji? Any other view on this? So it means the bankruptcy proceedings which start against the husband cannot percolate down to wife. Second, please.
Can his foreign travel be restricted? Who can impose such restrictions? He and his wife are thinking of leaving India forever to get out of this mess. A. Depending upon the stage of proceedings, there could be restrictions. Number B. His wife may not be restricted. Number C. Leaving India may not help. And number D is missing, I believe.
So,
number C.
What is the stage at which there are restrictions on foreign travel? Whether on admission of application, whether during bankruptcy only, or whether after filing of application, because there are 3 stages. There is a concept of interim moratorium here in case of individual insolvency and bankruptcy. This is all you know. And interim moratorium starts from the date of filing of the application. And once an application is admitted, then moratorium starts. So there are 3 stages: interim moratorium, and then bankruptcy. So where is this restriction applicable regarding foreign travel? Whether during interim moratorium, that means as soon as application is filed, or whether on admission of application, or in case of insolvency, this does not apply, and in case of bankruptcy only this applies. What is the exact situation and what is the section and regulation? Please quote with relevant section and regulation.
Section 85, sir, during the moratorium period, after the admission of application.
Okay, it means during interim moratorium, he can travel overseas. If you are reading for 85, then you are reading fresh start process. But this is not fresh start process. Number 1.
95.
Yes, 94 is in case of application by debtor, and 95
Debtor
is
and
application
95 is application by the creditor.
by the creditor. So here who has filed the application? Here I think the banker has filed the application.
Banker.
Is it written somewhere that banker has filed the application?
तो सर वो सिक्योरिटी इन्वोक करने की बात लिखी.
Yes, yeah. हाँ, so security invoke है, तो ये we can assume that banker has filed the application.
Banker has filed.
So 95.
95.
कौन सा section है? What is the section, please?
95.
अच्छा, 95 में कहाँ लिखा है ये बात कि इसको रिस्ट्रिक्शन हो जाएगी? कहीं लिखा भी होगा ना कि भाई कैन नॉट ट्रैवल ओवरसीज. आपको बताना पड़ेगा कहाँ लिखा.
ऐसे कुछ नहीं है।
85F,
हाँ जी
85
वो अलग है, वो फ्रेश स्टार्ट प्रोसेस है।
85
इसमें
तो
नहीं
फ्रेश
है
स्टार्टर है,
95।
जो उसको भूल जाओ आप।
हाँ,
अच्छा
95 में नहीं है।
आपको सेक्शन बताना पड़ेगा ना,
सही कह रहे थे
तो सेक्शन बताइए कौन सा सेक्शन।
सर। मेरा ख्याल है शायद बैंक्रप्सी में रहेगा, इसमें नहीं रहेगा।
हाँ तो वही ना, बताओ ना जी, बताओ ना कहाँ
एब्सोल्युटली
आएगा।
राइट।
सेक्शन तो बताना पड़ेगा ना जी।
नहीं, बैंक्रप्सी का जी।
हाँ जो भी है जी, मतलब जहां रिस्ट्रिक्शन है ये। बात तो ये है ना जी, आप इंसॉल्वेंसी प्रोफेशनल हैं, आपके पास वो आया है एडवाइस लेने के लिए। वो कह रहा है जी मुझे बाहर जाना है, मेरी कजिन की मैरिज है, मैं जा सकता हूँ नहीं जा सकता, वो आपसे पूछ रहा है, आपको बताना है। वो तो ऐसे ही पूछेगा ना आपसे।
There is no such restriction.
141 सेक्शन 140।
141 है सर।
हम्म है, बिल्कुल है जी रिस्ट्रिक्शन। विलियम राजू जी आप बोल रहे हो रिस्ट्रिक्शन नहीं है, आप तो मरवा दोगे उस बंदे को।
141 1F।
1F,
रिस्ट्रिक्शंस ऑन
141
बैंकक्रप्ट।
हाँ
तो 141 1F, नॉट बी परमिटेड टू ट्रेवल ओवरसीज विदाउट द परमिशन ऑफ द एडजुडिकेटिंग अथॉरिटी। तो ये आपका सेक्शन आ जाएगा
141।
तो क्या इसमें
141
कौन सा ऑप्शन रहेगी?
बैंक्रप्सी सर।
नहीं, ए बी सी में से कौन सी ऑप्शन रहेगी?
ए तो डिपेंडिंग ऑन द स्टेज ऑफ प्रोसीडिंग्स देयर
नन
कुड बी
ऑफ द
रिस्ट्रिक्शन।
अबव है सर।
नहीं
नहीं,
मैम,
अगर ये तीन ही ऑप्शन दी होगी तो क्या करोगे?
ए
ए आएगा सर, ए।
हाँ यही आएगा। तो यहां हम लिख देंगे सेक्शन 141
1F
1F। ये 10 हो गया, ये 1 है। और इससे पहले वाला जो क्वेश्चन था, इसमें आंसर था ए। थर्ड क्वेश्चन देखिए, कैन देयर
और
पर्सनल असेट्स बी अटैच्ड? एक एक का आंसर दीजिए। को अटैच कर
नहीं
सकते नहीं
सर,
कर सकते?
कार को नहीं अटैच कर पाएंगे
क्यों?
क्योंकि वो मोड ऑफ ट्रेवल है फॉर गोइंग टू देयर जॉब्स।
हाँ ठीक है जी, तो दे मे नॉट बी अटैच्ड, ये तो करेक्ट हो गया। अच्छा दूसरा, इंश्योरेंस पॉलिसीज में बी अटैच्ड आफ्टर पेइंग ऑफ फ्रॉम सरेंडर वैल्यू, क्योंकि इंश्योरेंस पॉलिसी पे उसने लोन ले रखा है।
हाँ सर, वो दे फिर देना पड़ेगा उन्हें।
वो हो सकता है सर।
एनकम्बर्ड।
गोल्ड ज्वेलरी
गोल्ड ज्वेलरी में क्या होगा?
above rupees 1 lakh rupees।
और चौथा, प्रॉपर्टी इन द ट्रस्ट।
नहीं सर, वो
Can't be-
वो नहीं हो पाएगा क्योंकि बच्चों के लिए ट्रस्ट बनाया हुआ है।
ठीक है जी,
This is excluded assets ना sir?
ऐसा ही कोई लगता है।
एक्सक्लूडेड एसेट्स, यू राइट।
अच्छा ये वाला देखिए, ये क्वेश्चन देखिए क्या बोलता है।
Can you help him in filing an application for individual insolvency?
Hmm.
What is more beneficial?
Hmm.
He himself filing an application or the banker filing an the application? What are the documents you require for this purpose?
भाई वो बोलेगा ऐसा है जी, मेरी इंसॉल्वेंसी तो होनी ही होनी है, तो बैंक गारंटी वो खो चुकी है। अब मैं खुद एप्लीकेशन फाइल करूं या बैंकर को फाइल करने दूं, कौन सा बढ़िया रहेगा? आप बताओ, आप इंसॉल्वेंसी प्रोफेशनल हो।
खुद फाइल करना अच्छा रहेगा सर।
क्यों?
उसमें एटलीस्ट ही कैन सेट हिज रीपेमेंट प्लान। और
वो तो बैंकर करेगा तो भी कर सकता है, उसमें क्या
नहीं
होगा?
नहीं सर, फिर वो बैंकर अपने हिसाब का वो करेगा ट्रस्टी, उसमें एक्सपेंसेस ज्यादा होंगे। ये इंडिविजुअली करेगा, कम होगा।
एक्सपेंसेस का क्या फर्क होगा मैम?
फर्क होगा सर, बैंक इंस्टीट्यूशन करेगा और आप खुद करोगे, उसमें फर्क है ना सर।
क्या फर्क होगा, वही तो
नहीं,
पूछ रहे हैं।
आपने अगर इंसॉल्वेंसी प्रोफेशनल चूज कर लिया तो क्या
हाँ।
बैंकर उसको चेंज नहीं कर सकता?
कर सकता है सर।
अगर कर सकता है, कौन से सेक्शन में लिखा कर सकता है?
एक मिनट सर, स्टैंडर्ड ऑफ बैंक
ना-
ये नेम फॉर कंडक्ट सर्च
98 में है सर, कोई भी कर सकता
सुनील जी को तो सब सेक्शन रटे हुए हैं, सर।
है। वो नहीं है मैम,
कोई
जो
नहीं,
आप
98 में देख लीजिए, थोड़ा जल्दी के लिए बता देते हैं सुनील जी, और कोई बात नहीं,
जल्दी के लिए बता
वरना
देते हैं,
ढूंढते
तो
रहेंगे फिर और क्या।
मतलब आई रियली वंडर कि आप दोनों को तो एकदम रटा हुआ है, बाकी सबको भी है थोड़ा बहुत, बट आप लोग का तो एकदम।
मेरे को मत इंक्लूड करो, मुझे कुछ नहीं रटा हुआ।
सर आपसे ही तो सीख सीख के हम लोगों ने किया है, क्या बात करते हैं।
हम्म,
लेकिन वो तो
98
सर अगर बैंकर ने भी आरपी लगा दिया तो उसको भी बदल सकते हैं।
हाँ हाँ, 98(1) में सर बदल सकते हैं। टू अप्लाई टू ए फॉर रिप्लेसमेंट ऑफ द सच रेजोल्यूशन प्रोफेशनल, उसमें
वो
वही
डेटर हो
होगा कि
चाहे
फिर वो
क्रेडिटर हो।
बोर्ड को रेफर करेगा, बोर्ड कंफर्म करेगा विद इन 10 days, तब हो सकता है।
भाई अगर क्रेडिटर लगाएगा तो कह दे, डेटर कह देगा इसको चेंज करो, डेटर लगाएगा तो क्रेडिटर कह देगा चेंज करो। अगर उनको कोई दिक्कत है, पूछना, बताना पड़ेगा रीजन, ऐसा नहीं खाली चेंज करो, कुछ ना कुछ तो बताना पड़ेगा। अच्छा, इसके अलावा क्या इसमें कोई कमेटी ऑफ क्रेडिटर भी चेंज कर सकती है क्या?
सर कमेटी
जो
ऑफ
अगर क्रेडिटर्स जो हैं,
हम्म,
भाई क्रेडिटर्स की भी मीटिंग भी कॉल कर सकता है ना ये? इंसॉल्वेंसी में मीटिंग कॉल होती है क्रेडिटर्स की या नहीं होती?
सर अगर वो जरूरत समझता है तो बुलाते हैं। If they
अगर
feel
अगर
they
अगर मान
really need.
अगर हाँ ठीक है, अगर वो क्रेडिटर कहें कि भाई लेट अस रिप्लेस दिस आरपी, तो हो सकता है क्या? क्रेडिटर के कहने पे हो जाएगा? नहीं होगा। भाई मान लो
हाँ
उन्होंने क्रेडिटर की मीटिंग
सर,
बुलाई, हाँ जी,
where the debtor is or creditor is of the opinion, that means creditors may change. The 98 states that where the debtor or creditor is of the opinion.
सर
That
यहाँ एक थोड़ा सा सवाल है कि क्या इज देयर एनी सीओसी इन इंसॉल्वेंसी ऑफ इंडिविजुअल?
No, sir. There is a committee of, I think,
इज देयर एनी कमेटी? इफ देयर इज अ कमेटी इट इज सीओसी।
no,
कमेटी तो नहीं है।
कंसल्टेशन कमेटी,
consultation committee है ना सर,
स्टेक होल्डर्स कमेटी,
यहाँ कहाँ है
इंसॉल्वेंसी में कंसल्टेंसी कमेटी कहाँ है?
अरे वो तो लिक्विडेशन में है जी,
स्टेक होल्डर्स कमेटी।
यहाँ कहाँ है? यहाँ कुछ नहीं है, यहाँ सिर्फ
बहुत
मीटिंग
तेज
होती
हल्ला
है
कर रहे
क्रेडिटर्स
हैं।
की बस।
आज मुझे रीड करना है, मेरा भाई कौन है, बहुत हल्ला कर रहे हैं आप लोग।
हाँ जी, हाँ जी।
हाँ
तो
तो है ना
सीओसी
सर, है
सीओसी
सर, बोल रहा है ना
हाँ,
107 समनिंग ऑफ मीटिंग ऑफ क्रेडिटर्स।
मीटिंग
वो
ऑफ
ठीक है,
क्रेडिटर्स है ना मैम?
वो तो ऐसा है, क्रेडिटर की मीटिंग बुलाएगा, लेकिन उनकी कोई कमेटी नहीं बना रहा,
हाँ
ना
हाँ,
ना
अच्छा
ही कोई
हाँ,
परसेंटेज है।
COC या कोई कमेटी नहीं है। अगर कंसल्टेशन करना है या कुछ बात कहनी है तो बुला सकते हैं।
हाँ बस बस बस।
कॉलिंग द मीटिंग एट लीस्ट 14 days बिफोर, ठीक है।
क्योंकि क्योंकि
नो
क्योंकि
परमानेंट
इसमें मैम, इसमें जो है ना, अगर आप सेक्शन 79 में जाएंगे,
हाँ हाँ
79(11) में कमेटी ऑफ क्रेडिटर्स की डेफिनेशन दी हुई है इसमें, और उसमें वो क्लियरली कहता है मींस अ कमेटी कॉन्स्टिट्यूटेड अंडर सेक्शन 134 व्हिच कम्स इनटू बैंक्रप्सी।
हाँ हाँ
सो इंसॉल्वेंसी में देयर इज नो कमेटी, क्रेडिटर्स हैं।
तो लेट अस डिस्कस दिस पॉइंट कि भाई क्या फायदा, कुछ फायदा है क्या? वो पूछ रहा है आपसे, ऐसा जी मैं खुद फाइल करूं, बैंकर फाइल करे, तो दोनों से एक ही सिचुएशन है या इसमें फायदा है? अगर फायदा है तो क्या फायदा है, बताइए जरा। भाई 94 भी हो सकती है, 95 भी हो सकती है, तो कौन सी बेटर है? कुछ बेटर है क्या दोनों में से कोई, या बराबर ही है?
94
दोनों में भी पैसे देने का।
पैसा तो है ही,
ऐसा तो देना ही है।
पैसा तो आरपी की फीस तो
whatever
देनी है।
whatever is excluding keeping
अच्छा, आरपी की फीस कौन डिसाइड करेगा इसमें? आरपी, भाई आरपी अगर आप रखोगे उसको फीस तो डिसाइड करोगे ना, तो कौन डिसाइड करेगा? एडजुडिकेटिंग अथॉरिटी डिसाइड करेगी, एप्लीकेंट डिसाइड करेगा, कौन डिसाइड करेगा?
तो रीपेमेंट प्लान में डिसीजंस होगी सर,
हैं?
रीपेमेंट प्लान में डिसीजंस होगी कितना आरपी
नहीं,
का फीस।
रीपेमेंट प्लान तो वो अभी तो
उसमें है,
बाद में
लिखा है।
आएगा। अब
लिखा
वो
तो है।
आप तो उसको आज बुला रहे हो, वो कहेगा भाई मेरे बिना पैसे मैं तो मूव करता नहीं।
करेक्ट।
तो वो उसको देने हैं पैसे, नहीं देने, देने हैं तो कौन देगा? कहाँ लिखा है? कहीं लिखा है क्या?
लिखा है ना,
कहाँ?
सेक्शन 1053 देखिए, सेक्शन 1053 प्रोविजन।
अच्छा,
हाँ है ना,
क्या लिखता है इसमें?
प्रोविजन फॉर पेमेंट ऑफ
द
फीस टू
रीपेमेंट
तो
प्लान शैल
प्रोविजन है
इंक्लूड
सर,
द
ये तो
फॉलोइंग।
प्रोविजन है।
ये तो ये है कि जब रीपेमेंट हो तो उसमें उसके भी फैक्टर इन कर लो, आप कि प्रोविजन
एक्चुअली
कर लो
उसमें
फॉर रीपेमेंट।
डिसीजंस होगी तो उसके बाद वो बात चीज का कंसीडर किया जाएगा।
नहीं वो ठीक है। अब ऐसे है ना भाई, अब वो आपके पास आया है जॉन, ठीक है, यू आर एन इंसॉल्वेंसी प्रोफेशनल, भाई मैं बोलूंगा भाई मेरी तो 1 लाख रुपए फीस है, तो वो देगा नहीं देगा? देगा तो कहाँ क्या होगा? क्रेडिटर मान लो नहीं माने, ज्यादा दे दी तुमने फीस, क्या होगा इसका? फीस के बारे में कहाँ पर है? या रीपेमेंट प्लान बनने तक कुछ दोगे ही नहीं उसको?
नहीं सर,
ऐसा
ऐसा
तो नहीं हो सकता। तो कहाँ लिखा है? कहीं तो लिखा होगा ना।
सर इसके फीस के बारे में तो साइलेंट ही है ना जी, वो फीस तो जैसे CIRP में भी फीस के बारे में तो कुछ नहीं है ना जी।
नहीं वो तो लिखता है ना जी, एप्लीकेंट देगा।
हाँ उधर
वो तो सिर्फ IRP तक है ना जी, RP के लिए तो कुछ नहीं लिखा हुआ है। वो तो
ना वो तो फिर IRP के बाद तो RP बनेगा ना।
COC करेगी ना उसको।
IRP के बाद तो आरपी आता है।
अब यहाँ पर कहीं लिखा नहीं कुछ, क्या होगा इसकी फीस का? क्या होगा?
सर जो अपॉइंट करेगा वो देगा। अगर ये बैंक करता है तो बैंक पे करेगा, बिकॉज ही हैज टू अप्लाई थ्रू द इंसॉल्वेंसी रेजोल्यूशन प्रोसेस में आरपी तो लगाना ही पड़ेगा ना सर दोनों को। तो जो आरपी
हाँ,
को
हाँ।
अपॉइंट करेगा, ये बैंकर अपॉइंट करेगा तो 95 के हिसाब से बैंकर देगा, और अगर डेटर देगा तो उसको फी देना पड़ेगा। 94 अगर
सर ये जो
अप्लाई
रेगुलेशन
करेगा।
है, ये जो रेगुलेशन है
बेसिकली क्या है, मुझे ऐसा लगता है कि ये पैसे देने अल्टीमेटली उसको ही है,
सर, ये
जो बंदा है, जो जिसकी इंसॉल्वेंसी हो रही है, वो तो चाहे क्रेडिटर अपॉइंट करे चाहे वो खुद अपॉइंट करे, देने तो बैंक, देने तो उसको ही है, जॉन को ही देने
बोल रहा है ना,
है।
रेगुलेशन 3I में बोल रहा है, रेजोल्यूशन प्रोसेस कॉस्ट शैल मीन फी पेबल टू द रेजोल्यूशन एप्लीकेंट,
हाँ ठीक है।
रेजोल्यूशन प्रोफेशनल।
Actually, it will be included in the insolvency cost, and it
अरे
will be
भाई
there by
बात तो
the
पैसे देने
bank.
की हो रही है। अब जॉन पहुंच गया इंसॉल्वेंसी प्रोफेशनल के पास,
It will be paid by the bank.
बैंक
नहीं सर, ये
नहीं,
क्या
नहीं।
बोल रहे हैं? देखिए सर, if we see the definition 3I whole, then we can get some information.
कौन सी डेफिनेशन?
Regulation
वो सर
3,
रेजोल्यूशन प्रोसेस कॉस्ट में द फी पेबल टू द, उसी के बारे में वो जो 105 कह रहे थे उसी का जिक्र है कि उसका
उसमें
प्रोविजन
क्या
करके
कह रहा है?
चलना।
To the extent approved and ratified by the creditors.
हाँ तो ये ठीक है।
हाँ, expenses incurred, finances raised, such other costs directly relatable to the resolution process to the extent approved or ratified by the creditors.
वो तो बात की बात है, वो फीस की बात नहीं कर रहा,
हाँ,
दैट इज नॉट फीस, वो तो
नहीं,
expenses है।
नहीं फी की बात कर रहा है ना, 3I का 1 fee payable to the resolution.
मैम दैट इज राइट, दैट विल बी सर्च पॉइंट वाज दैट हु इज लाइक, जैसे वहां IRP की कॉस्ट के लिए स्पेसिफिकली लिखा हुआ है कि एप्लीकेंट विल फिक्स द कॉस्ट।
फी कौन फिक्स कर रहा है?
यहाँ पर कहीं लिखा नहीं है इट इज द पार्ट ऑफ द इंसॉल्वेंसी कॉस्ट।
सर इन्फ्रेंस आ गया ना कि जो रेटिफाई होगा वही मिलेगा, तो CD चाहे जिस भी रेट।
मैम वो जो रेटिफाइड है वो उसके लिए सच अदर कॉस्ट डायरेक्टली
वो अलग से फीस नहीं है वो
सर
फीस
सबके लिए। सर देखिए आप इन टोटालिटी पढ़ेंगे ना हम लोग।
नहीं वो सिर्फ 4 के लिए है, आप जो फीस है बेसिकली इसकी इंसॉल्वेंसी बेस ये है, इंसॉल्वेंसी प्रोसेस कॉस्ट का हिस्सा होगी। तो इसीलिए उसने कहा है कि प्रोविजन आपको रीपेमेंट प्लान में रख के चलना पड़ेगा।
अगर वो बैंकर भी पे करेगा तो अल्टीमेटली डेबिट तो इसके अकाउंट में ही होगा सर, सीडी के अकाउंट में डेबिट तो होगा।
बिल्कुल बिल्कुल बिल्कुल।
भाई कुल्हाड़ी में पैर दे या
हाँ
कोई भी दे जिसकी इंसॉल्वेंसी हो रही है उसी को पैसा देना है।
बस वो चाकू खरबूजे पे गिरे या खरबूजा चाकू पे कटेगा, खरबूजा ही, वही बात है।
क्योंकि इसमें आरए का कोई कॉन्सेप्ट नहीं है ना, कोई बाहर से तो आके उसको
हाँ
टेक ओवर
बिल्कुल
नहीं कर
बिल्कुल,
रहा
उसी को देना
है, ये
हाँ।
खुद ही करेगा जो भी।
सीडी को ही देना है।
अच्छा, अब ये when you are filing an application, so what are the documents you require for this?
एप्लीकेशन फाइल करते समय सर
क्या क्या डॉक्यूमेंट्स लगाने होंगे?
डिमांड नोटिस
सर 2 साल का बुक्स ऑफ अकाउंट जाएगा सर, और उसके
भी
साथ
करेगा
में
तो demand
एसेट्स एंड
notice
लाइबिलिटीज की लिस्ट भी जाएगी सर।
Details
एक
of
तो
the debt.
रेगुलेशन 7 पढ़ सकते हैं हम इसमें,
हाँ सर, रेगुलेशन 6 और 7 में दिया
10 भी पढ़ सकते हैं।
है डिमांड
रेगुलेशन में पूरा डिटेल दिया हुआ है कि क्या क्या होगा इसमें, और अगर एप्लीकेशन बाय गारंटर है तो रेगुलेशन 6 भी पढ़ सकते हैं, 6 और 10 पढ़ सकते हैं, तो 6 और 10 से आइडिया हो जाएगा। अच्छा, इसमें विड्रॉल का भी कोई प्रोविजन है क्या? एक बार एप्लीकेशन हो गई तो विड्रॉ हो सकती है?
हाँ सर।
तो कौन विड्रॉ कर सकता है?
सर जिसने फाइल किया होता है ए में परमिट रेगुलेशन 11 बोल रहा है ना, परमिट विड्रॉल ऑफ द एप्लीकेशन सबमिटेड अंडर 2, 6 और 7।
ठीक है, अगर एक बार एडमिट हो गई तो एडमिट होने के बाद में क्या होगा? एडमिट होने के बाद में कुछ है क्या भाई, इतने क्रेडिटर्स को एग्री करना है या कुछ परसेंटेज है या क्या? जैसे आईआरपी में परसेंटेज है तो यहाँ भी कुछ परसेंटेज है या नहीं है? रेगुलेशन 11 देखिएगा एक बारी। एप्लीकेशन टू एडजुडिकेटिंग अथॉरिटी फॉर इंसॉल्वेंसी रेजोल्यूशन प्रोसेस रूल्स में देखिएगा। रूल्स में आप 11 रूल देखिए, रूल 11 क्या बोलता है जी, पढ़िए उमा मैडम।
हाँ सर, ये बोल रहा है आफ्टर इट्स एडमिशन, और 11 भी बोल रहा है, रूल 11(1)(b is saying after its admission on the request made by the applicant, whosoever it is, maybe creditor or debtor, if 90% of the creditors agree to such withdrawal.
हाँ, तो ये भी एक इम्पोर्टेंट पॉइंट है,
12A की
वो
तरह।
पूछ सकता है कि भाई एक विड्रॉल के बारे में भी पूछ सकता है।
हाँ, यही सब सर 1 मार्क के, तो ये क्वेश्चन पक्के इसी को हम लोग वो मिस करना जाए।
बिल्कुल बिल्कुल। चट्टोपाध्याय जी, आप चुपचाप बैठे हो, कोई एक आध सवाल आप पूछ लो।
नहीं ठीक है सर, हम सुन रहा हूँ, अभी तो जस्ट थोड़ा ये हो गया, मैं देख लेता हूँ। नहीं ठीक है सर, कोई इशू नहीं।
Can he take divorce from his wife on paper? भाई वो कहता है वो
Not
ये
required sir, ना।
अच्छा ठीक
When
है,
it is bankruptcy against him, his wife is
ठीक है।
not to be involved.
तो वाइफ का कुछ रोल रहता है क्या इंसॉल्वेंसी में? नहीं रहता।
Question number 4 we have not answered, sir.
Which is more
क्वेश्चन नंबर 4
beneficial?
तो जनरल था, we have discussed in detail.
What is more beneficial?
नहीं which one is beneficial वो बोला नहीं।
Which
वो
one is,
decide नहीं हुआ।
हाँ which one is beneficial में तो देखिए ऐसा है, वो बराबर ही रहेगा, उसमें कोई फर्क नहीं पड़ेगा। बट फिर भी अगर ऐसा है कि नॉर्मली क्या होता है, अगर वो अपने आप ही कर ले तो ज्यादा बेटर है, क्योंकि अगर चेंज करना चाहेगा बैंकर आरपी को तो उसको एप्लीकेशन लगानी पड़ेगी, उसको रीजंस देने पड़ेंगे, तो वो अपनी चॉइस का रेजोल्यूशन प्रोफेशनल अपॉइंट कर सकता है। होता क्या है इसमें ना, पर्सनल डिटेल्स भी देनी पड़ती हैं, एसेट्स वगैरह सारे डिटेल देनी पड़ेगी। तो कई बार क्या होता है, मान लो उसकी चॉइस का ही कोई चार्टर्ड अकाउंटेंट है, कोई जो इंसॉल्वेंसी प्रोफेशनल है, तो उसके साथ वो इन्फॉर्मेशन शेयर करना उसके लिए इजी रहेगा। ये बात
And
है।
he can also negotiate the fees of RP.
यस यस, हाँ वो भी बात है। तो इट इज ऑलवेज बेनिफिशियल, वो अगर वो खुद ही फाइल करे तो बेटर है। और ये वाला जो था इसकी कोई जरूरत नहीं है। अच्छा ये बताइए, वाइफ का क्या रोल रहता है इंडिविजुअल इंसॉल्वेंसी में? कहीं वाइफ का कुछ रोल आएगा नहीं आएगा? उसके एसेट्स कहीं काउंट होंगे?
अनरिलेटेड,
हाँ जी,
अनरिलेटेड वाइफ,
अनरिलेटेड।
But if you husband transfer property to his wife, that is anything is there bearing on that?
वो तो
नहीं,
एक
नहीं,
तरीके से malicious
एसोसिएट तो है ना सर,
एसोसिएट है,
एसोसिएट तो है ना।
एसोसिएट है और इमीडिएट फैमिली मेंबर है, इमीडिएट
member
फैमिली
है।
ऑफ द डेटर है.
हाँ, चलिए।
Sir, kindly in English, sir. We are
Please
unable
in
to-
English, sir, to reach everyone. It's a very good
Yes,
class.
yes.
Please,
So
please in English.
wife actually is
Associated with the
immediate relative.
debtors.
Please in English, sir,
Wife is
to
immediate
reach in
family.
everyone.
Wife is immediate family of the debtor. So it is important. So immediate family of the debtor means his spouse, dependent children, and dependent parents. Number one. And then there is definition of associate also. So associate includes associate of the debtor.
Sir,
This is-
but what is the role of associate? Like,
Asso-
if he is
associate
transferring something to his wife or any third party maliciously, that will always be subject to the examination. But otherwise, suppose wife has some assets. I have this query. Suppose wife has some personal assets. She is working. She might have her house. She might have her jewelry. She might have her other assets. Then I don't think those assets will be in any way will be related to the bankruptcy assets.
basically for PUFE transactions, this is important.
That associate will be
Absolutely.
relevant only there,
Absolutely.
whether it is wife or anybody else. Yes, sir.
Yes, that is true. But regarding associates, I think details of assets of the associates also has to be disclosed. So let us please see the form.
Details of the associate has to be given. That's right. What you're saying, sir.
So that is important. So details of the associates have to be given. And regarding these PUFE transactions, this role of associate will come.
That only I'm saying that too, for any related party it will come.
No, but besides that, I think even details of the associates have to be given. Let us please see the form.
What is the form number?
Form number just. Chattopadhyay ji, please tell me the form number
फॉर्म नंबर है आपका,
for filing of application.
फॉर्म नंबर BC शायद,
A or something like A, B to some form. Form A is application by guarantor. Form B is
Form A is debtor. Form B is creditor.
Form
B.
it is given in application to adjudicating authority for insolvency resolution process rules.
Yes.
So you have to
Form
see
C
the
public
rules.
notice, Form D notice for creditors.
Yes. So form B is from form of demand notice, and form C is application by creditor.
Creditors.
Documents for filing.
List of associates of the guarantor. So if you see, I am reading from Insolvency and Bankruptcy application to adjudicating authority for insolvency resolution process rules. And this form is form C part 2. So form C
The
part
rule
2,
number?
point number 7.
So can you
List
tell
of
the page
associates.
number, please?
Compendium 3.7a.12.
3.7A.
0.12.
सर इसका 11 पढ़ लीजिए ना, 11 है.
मेरी मीटिंग चल रही है, बाद में करते सर बात. हाँ जी.
Point number 11 पढ़े ना सर. List of assets of the guarantor as on application date.
हाँ.
This will include all the assets of guarantor irrespective of being excluded.
हाँ, उससे पहले वो 7 पॉइंट में आ जाएगा. लिस्ट ऑफ एसोसिएट्स ऑफ द गारंटर इंक्लूडिंग.
नहीं सर, वो तो आ जाएगा. अगर वो खुद ये है, ये जो आप पढ़ रहे हैं, this is when it is the application by creditor. अगर वो खुद कर रहा है डेटर, तो उसके 11 में कह रहा है लिस्ट ऑफ द एसेट्स ऑफ guarantor and immediate family as on the application date.
अच्छा, हमारे में इमीडिएट फैमिली लिखा नहीं, बोल रहा लिस्ट ऑफ एसेट्स ऑफ द.
नहीं मैम, आप फॉर्म ए देखिए, फॉर्म ए.
फॉर्म ए.
यस,
1 minute.
फॉर्म ए पॉइंट नंबर 11.
ओके सर. Point number 11. हाँ सर, इसमें तो आ जाएगा।
और नोट के अंदर वो कह रहा है एक्सक्लूडेड है क्या है, इससे उससे कोई मतलब नहीं, सब देना है उसको।
सब देना है। Thereafter, I think it will be decided what is excluded, what is not excluded.
Yes. नहीं वो आगे है डिस्क्रिप्शन
Right.
में ना, एक्सक्लूडेड एसेट्स और नॉट।
So
वो आगे
assets तो
application में है।
assets will come here.
Yeah.
हाँ,
Why?
अगर वो
Because
अगर वो
on this basis they will see कि भाई whether such assets were transferred during this period for PUFE transactions purpose. That could be one purpose. Because
ये
once all
तो-
these details come, so then the liquidator can assess now whether these assets were transferred to his wife during such period. So whatever the period for PUFE transactions. वो section 164 है या जो भी section है.
Otherwise, the assets of wife cannot be attached, I suppose.
No, that is true, but you have
section
to
I
give
don't
the
remember,
details.
But this, as per law,
but जो credit-
You have to give the details because the liquidator might like to see कि whether there was any recent transfer of assets from one person to another.
that is right.
क्योंकि
इसमें
इसमें एक चीज और है ना सर कि एनी ट्रांजैक्शन है वो, कोई भी ट्रांजैक्शन अगर करता है विद द रिलेटेड पार्टी और एसोसिएट्स विद इन 6 months, तो वो माने ही जाएगी कि वो
Yes, it will be presumed that it is a POFE transaction. Yes.
PUFE transaction.
Yes.
Sir, लेकिन जो creditor will submit the form, there 11 is talking about only the list of assets of the guarantor as on the date of the application.
Please read the note also, no?
Note also. This will include all assets of guarantor, irrespective of them being excluded. This is a creditor's form.
And immediate family भी तो लिखा ना, immediate
No,
family
no,
wife
sir,
तो.
that is for debtor is written.
Ma'am, for if a creditor is filing,
Ah.
how he can have the access to the
Yeah.
assets of the associates or the immediate family?
That means he may be the guarantor may be called upon afterwards to submit something like that will be there. Huh?
No. Why you are presuming that it will happen?
Sorry, sir.
Basically, the logic is when he himself is filing, he knows what his immediate family has. How can a bank know that what his immediately family has as an asset with them?
जी सर.
खुद को तो पता ही है ना कि मेरी वाइफ के क्या क्या एसेट्स है. तो जब उसने गारंटी दी थी तो उसी के एसेट्स के बारे में तो लिया था. They must not have taken about all the family.
Yes. Next question.
इसका आंसर क्या है सर?
किसका?
5th one.
नहीं, कोई जरूरी, not required. Next question, Sandeep ji, please.
If he's really facing some problem in the married life, he can take the divorce, otherwise not. This is the
answer. His father-in-law told him that to show increased.
Actually, Sandeep ji, somebody was asking me, they have formed an HUF and he says that their case is under this family court for divorce. So whether before divorce has happened, whether they can do complete partition of HUF. मैं बोला भाई फिर तो सभी लोग ऐसा कर लेंगे. What they will do? They will do complete partition and then they say, okay, we don't need divorce. बोला कि भाई, so I told them that please take divorce first. Then you get this settlement deed registered with the registrar and then you do family partition. HUF.
Then unite.
Yes.
नहीं सर, ये जो अभी जाजू जी कह रहे हैं, this has happened, a very interesting case.
Yes.
The husband took a loan and then he divorced his wife and the wife claimed all his assets as an alimony, which was granted by the court to the lady. And now they are legally divorced. उसके ऊपर किसी का कोई असेस नहीं है, किसी का कोई वो नहीं है, सारी प्रॉपर्टी, the property has gone to the wife. No, the wife and husband are staying together, and wife is a tenant to the like husband is a tenant to the wife. They are staying in the same house.
Yes, income from house property allows this. Income Tax Act also.
Yes.
Unless there is an agreement to live apart. So
only
So-
because of कि उसको कोई उसकी property attach ना कर सके, so he gave divorce to the wife on the papers.
Yes.
And he settled with the court itself. वहां कुछ पैसे वैसे दिए होंगे, तो कोर्ट ने कहा कि जो भी इसकी प्रॉपर्टी सारी सेटलमेंट में ट्रांसफर टू द नेम ऑफ वाइफ.
Yes, please, Sandeep ji.
Yes, sir.
Question.
His father-in-law told him that to show increased turnover, he had booked some fictitious purchases and sales and had done round tripping. As a result, the liabilities being shown in the books are not actual liabilities. In case his father-in-law admits this fact before AA, can there be some relief?
Actually,
Relief.
sometimes what happens is, just to show the increased turnover, they do purchase and sales from the same party. Or A is selling to B is selling to D, then D is selling to E, and E again is selling to A. So this way, all the parties can book their turnover.
Accommodation transaction.
Yes. So where is the provision regarding such type of transactions here? Whether there is any such provision in insolvency, or whether during liquidation only, whether during bankruptcy only. Whether in case of insolvency, a resolution professional can file this application for PUFE transactions, or such provisions are there in case of bankruptcy only. What is your take on this?
This is a fraudulent transaction.
No, but regarding during insolvency, can an application be filed by a resolution professional for such transactions, for fraudulent transactions?
During bankruptcy only, sir.
Acha. So during insolvency, there is no such provision?
But bankruptcy, there is a provision, but insolvency, there is no such provisions.
Yes, because actually in insolvency, he might pay all the liabilities. So once he pays all the liabilities, he is issued a discharge order. And if he doesn't pay, then the creditors are entitled for bankruptcy. So this insolvency is a time, it is some sort of, say, stopgap arrangement type. So ultimately, the result will be known after this repayment, or after inability to pay. In case there is an inability to pay, then bankruptcy will happen. And in case he is able to pay, then all are happy that they've got whatever they want to get.
Sir, such work is done by a rice miller here. What he did is he purchased the rice in the form of rice, or the raw rice, and then he made his turnover so much, and he took a loan of CC limit of 20 crores of rupees.
Yes, this is normal practice by businessmen. Yes.
Then he put his factory on fire, and the claim was rejected by the insurance company. So this even now, then it has gone to liquidation now, I suppose, at our place, Bilaspur.
Now in Bihar, I think 10-15 years ago, this was a routine practice which was followed by some of the businessmen. What they did, they showed lot of stocks, and then they told that, okay, this has been destroyed in fire. They took insurance policy, and then they took insurance claim from insurance company. But there was no stock at all. But they showed stocks. They took loan from the bank. They set it on fire, presumably. But वो कुछ था ही नहीं, तो fire क्या लगनी थी उसमें? But they took insurance money also from the bank, from the insurance company. But बाद में पता चल गया भाई ये सब fraud कर रहे हैं, तो बाद में वो रुक गया practice. But some people enjoyed. Next question.
What is the maximum period by which he may out?
इसका आंसर क्या है सर? 6 का.
किसका? 6 का आंसर ये है कि during insolvency, I think PUFE application cannot be filed. It is during bankruptcy only that such things can be taken up.
Okay.
What is the maximum period? So what is there any time period for this insolvency? Like in CIRP, there is a 180 days period. In pre-pack, it is 120 days. So what is the period here?
Maximum 1 year.
Huh?
1 year maximum.
180
Where
days.
is it written?
120 days है सर.
मुझे भी 120 लग रहा है, but
120 days
कहाँ पर है?
120 रेगुलेशन में है ना सर. Regulation 19 we have
Hmm.
filing the adjudicating authority.
That is not for completion. That is for something else, what you are referring to. So please read that.
But there must be some period. I also feel it is 120, but let us see where it is written.
In your notes only, it is 180 days, sir, if I remember correct.
Moratorium is talking about 180 days.
Okay.
Section 101, it says shall cease to have effect at the end of period of 180 days. So could be
What is this limit of 180 days, ma'am?
moratorium period. So that time will, I think, moratorium will run with insolvency.
Insolvency. That is for insolvency.
Please read the entire sentence.
Okay. When the application is admitted under section 100, a moratorium shall commence in relation to all the debts and shall cease to have effect at the end of period of 180 days, beginning with the date of admission of the application or on the date of the adjudicating authority passes an order on the repayment plan. Okay. Under section 114, whichever
This limit is for repayment plan.
अच्छा फिर आगे और जाना पड़ेगा नहीं समझ
तो आपने कब अटेम्प्ट लिया हुआ मैडम? लिया हुआ आपने? नहीं अभी?
सर मैं अप्रैल प्लान कर रही हूँ फर्स्ट वीक
नहीं, बढ़िया है, ठीक. तो स्टिल देयर इज 1 month.
हाँ 3-4 अप्रैल में. Contents of the नहीं voting meeting नहीं conduct
Ma'am, now come to regulation 17 and please read that.
Okay, sir.
Madam, also tell the page number, please.
अभी तो मैं ही पहुंच चुकी हूँ.
Which regulation, please tell me?
17.
Regulation 1.
Repayment plan.
Page number is 2.1.333.
Okay, sir.
Of compendium.
2.1.333.
Shekhar with 31.319, sir. Amen.
2.19333.
Yes, sir.
सर इसमें आंसर्स मीन्स ऑप्शंस नहीं है ना क्वेश्चंस के नीचे.
So what is the first 1A? The term of the repayment plan and its implementation schedule, including the amounts to be repaid and the dates of repayments to the creditor. So it means the schedule has to be given in the repayment plan. And now read section 117. The resolution professional shall within 15 days of completion of repayment plan forward to the persons who are bound to by the repayment plan under section 112 and the adjudicating the following documents: a notice that the repayment plan has been fully implemented and a copy of the report by the resolution professor summarizing all receipts and payments made in present repayment plan, extent of the implementation and such plan. The RP may apply adjudicating authority to extend the time mentioned in subsection 1, such further period not exceeding 7 days. So this is this schedule of the repayment plan has to be given in repayment plan only.
Haji, Chattopadhyay ji, your views on this?
हाँ सर, इसमें that is included in the repayment plan as per section 17.
117.
हाँ 117.
This is something like sir resolution plan में there is no specified date.
क्वेश्चन थोड़ा कंफ्यूज था, इसलिए मेरा
So here
क्वेश्चन
there is no specified date कि repayment plan कब करेगा.
हाँ.
Okay.
वो repayment plan में हो सकता है कि मैं साल भर में पैसा दूंगा.
So refer section 117 read with
regulation 17.
section 115, huh?
नहीं sir, regulation
17. First 17(1).
हाँ 105 था ये, section 105 regulation 17. कि 105 में तो रेफर कर रहा है ना, 105 refers to regulation 17. अच्छा ये तो इसका रिपेमेंट प्लान आ गया, इसको छोड़ो. अच्छा अब इसको लेट अस स्टॉप इट हियर, दूसरे वाली केस स्टडी देखते हैं. Now let us read this case study. संदीप जी पढ़िए जरा.
Yes sir, yes sir.
है ना?
So please move to page number 1.
Yes.
Amar Akbar Anthony Private Limited availed a loan facility from PNB to the tune of rupees 100 crores. The loan was booked by a personal guarantee of the loan was booked by a personal guarantee of the firm Amakan and Company, which had Amar Akbar and Anthony as its partners. Since Amar Akbar Anthony Private Limited is a software company, PNB decided to file the application against the firm Amakan and Company under Part 3 of the code. The repayment plan was not adhered to, and an application was moved by PNB jointly with SBI for bankruptcy of the firm, Mrs. Amakan and Company. PNB was nominated to act on behalf of all the creditors. Interim moratorium declared. Ramlal was proposed as the bankruptcy trustee. The BT found that the books are not complete. Firm has had a cinema hall on lease basis, and the BT was authorized to keep the cinema hall running. Besides this, the firm had a cold storage where spices, fruits, and vegetables were stored. The relatives of the partners have a similar cold storage chain and want to purchase the items stored in the cold storage. However, the price offered by them is 20% of the cost price. The father of Amar, one of the partners, expired and left property with rupees 10 crore, of which Amar was the sole legal heir. However, he secretly disposed of the property.
Hello, Ajay.
Yes, sir. Shall I continue?
Yes, please.
However, he secretly disposed of the property without the knowledge of the BT. A sum of rupees 5 lakh was spent by the BT to trace and recover such property. The lease deed of property contained a clause that on the termination of the lease, the lessor would be entitled for a compensation of rupees 20 lakh. However, on inquiry, it was found that the owner of the property of cinema hall was the grandson of the partners of the firm. SBI was a secured creditor having a security of cold storage. The value of the property as per the registered value is as under. Valuer A, 5 crore. Valuer B, 8 crore. SBI informed the BT that it wants to realize the cold storage property of rupees 10 crore. BT was able to find out another buyer who was willing to purchase the property at rupees 12 crores. The buyer was identified by a marketing consultant hired by the BT. However, the buyer did not turn up after initial deposit of rupees 1.2 crore and asked for further time due to COVID. One of the creditors, Sohan, who had filed a claim of rupees 50 lakhs, expired due to COVID. Akbar's sister lives in London. Her marriage is fixed on 7th July. He has booked his ticket for London. Since the BT was not well versed with the functioning of the cinema hall, he appointed Anthony to supervise the management of the cinema hall. On examination of the books, it was revealed that one of the properties belonging to the firm had been transferred to the daughter of wife of Akbar at market value. While bankruptcy proceedings were going on, Anthony expired. His legal representative had claimed a sum of rupees 1 lakh towards funeral and testamentary expenses. One of the employees of Amakan and Company, who had dues of rupees 20 lakh, is presently serving in Dubai. He is unable to come to India. However, the dues are properly reflected in the books.
Acha. Now, based on this, let me ask you certain questions.
जरा एक बार में पूरा समझ में नहीं आया.
दोबारा कर लो, दोबारा पढ़ लो सर, संदीप जी पढ़ लो. मैं
Yes,
बता
sir.
देता हूँ. Now let me read. ठीक है. मैं इसके साथ साथ क्वेश्चन, I'll be telling you the questions also. What are the questions? So actually there is a private limited company who has taken a loan, and there is a partnership firm which is being run by the directors of this private limited company. Akbar Anthony Private Limited is the private limited firm which has a well loan facility, and this firm which has all the directors, Amar, Akbar and Anthony, they are the partners, and they have given a personal guarantee. This firm has stood as personal guarantor to the loan availed by the private limited company. Now it is the choice of the banker, because they say that this Amar Akbar Anthony Private Limited, it is a software company, so there are not much assets in the company. So why we should waste our efforts in moving bankruptcy proceedings against this? So let us move directly against the partnership firm, because if you move against the partnership firm, you can move against the partners also.
Absolutely.
So partners are also covered.
Absolutely.
So the banker decided, okay, let us move against this partnership firm. So PNB decided to file the application against the firm, Amakan and Company. They gave a repayment plan. A repayment plan was they could not adhere to the repayment plan. And as we know, if you cannot adhere to the repayment plan, then bankruptcy proceedings are triggered.
Absolutely.
Now, this in case of bankruptcy, they have filed a joint application. So here there is a question whether a joint application can be filed. And if a joint application can be filed, in this case, PNB has been nominated to act on behalf of all the creditors. So whether there is any such provision to nominate one creditor on behalf of the others, this is another question here. So the first question will be whether the banker is right in moving against the partnership firm instead of first exhausting the remedies against the private limited company. This is the first question. Second question is whether a joint application can be moved. Third question is, in case a joint application has been moved, then whether one creditor can nominate the other to act on behalf of all the creditors. Next question is regarding the concept of interim moratorium. Whether interim moratorium concept applies during insolvency or bankruptcy as well, and how it is different from the moratorium concept. Are there any differences between the conditions attached in case of interim moratorium and moratorium? All these questions we will discuss tomorrow. We are simply discussing this case study and the probable questions which could be asked. Next is Ramlal was proposed as the bankruptcy trustee. BT found that the books are not complete. Now, there is another question. If books are not complete, then by what date the books have to be completed? Who has to complete the books? Whether he can hire a professional. Now, firm has hired a cinema hall on lease basis. And the BT was authorized to keep the cinema hall running. So there is another question here. Whether during bankruptcy, it can be kept as a going concern. Whether it has to be closed, the cinema hall also has to be closed, or it can be kept running
Absolutely.
during bankruptcy. Besides this, the firm had a cold storage where spices, fruits, and vegetables were stored.
Absolutely.
Now, next, the relatives of the partners, they have got similar cold storage chain. Now they want to purchase the items stored in the cold storage because the firm is under bankruptcy. So now, whether the relatives of the partners, they are entitled to purchase and at what price? The price which they are offering is 20% of the cost price. So whether this is adequate or not, or whether they can at all purchase the assets which
Absolutely.
belong to their relatives, what is the view on this regard during bankruptcy?
Absolutely.
Next is father of Amar. One of the partners expired and left property worth rupees 10 crore, of which the Amar was the sole legal heir.
Only.
Now, in case since the bankruptcy proceedings have been started against the firm, so all the three partners are involved. Now,
Absolutely.
one of the properties, they belong to the father of Amar, who is one of the partners, and father has left property worth rupees 10 crore, of which the Amar is the sole legal heir. However, he secretly dispose of the property without the knowledge of the BT, because it can very well happen. The bankruptcy trustee may not be aware of all the assets which their fathers or forefathers are owing. Suppose at the time this bankruptcy proceeding started, his father was alive, then later he expired. So now, because bankruptcy trustee was not aware of the uh, property which devolved on him after the death of his father, Amar has secretly disposed of the property.
Absolutely.
So now, in case he secretly disposes of the property, what will happen? Whether it can be claimed back? And a sum of rupees 5 lakh was spent by the bankruptcy trustee to trace and recover such property. What will happen to this 5 lakhs? Whether this 5 lakhs can form part of bankruptcy resolution process cost or what? Or whether it can be recovered from Amar. What is the position on this? The lease deed of property contained a clause that on termination of the lease, the lessor would be entitled for a compensation of 20 lakhs. Now, in this case, there is a clause that the cinema hall has been running on lease. But this lease, there is a condition that, okay, once you terminate the lease, you have to pay compensation of 20 lakhs. Now, the bankruptcy trustee inquired as to whom belongs this property. On inquiry, it was found that the owner of the property of the cinema hall was the grandson of one of the partners of the firm. Now, whether grandson is covered under the definition of associate, that we have to see. And if some compensation has to be paid, whether it can be challenged, whether it can be termed as undervalued transaction or overvalued transaction. What is the view on this? SBI was a secured creditor having the security of cold storage. So what are the provisions regarding this secured creditor? Whether secured creditor can take part in the votings of creditors, or whether he has to relinquish the security interest, or whether there could be secured part and unsecured part in case of secured creditor. What are the provisions during bankruptcy proceedings regarding secured creditor? That also we have to see. The value of the property as per registered valuer is this. Valuer A is valuing it at 5 crores. Valuer B is valuing it at 8 crores. Now, whether there is any provision for appointing a third valuer?
Yes.
Now,
It is more
against
than 10%. Yes.
against this 5 and 8, SBI informed the BT that it wants to, SBI is the secured creditor because SBI is having the security of this. So now SBI says that, okay, I have a buyer at 10 crores. Now BT says I have a buyer at 12 crores. This buyer was identified by a marketing consultant. Now who will bear the cost of this marketing consultant? Buyer did not turn up after initial deposit of 1.2 crore. Now what will happen to this 1.2 crore? Whether it will be forfeited and ask for further time due to COVID, whether further time can be given. If time can be given, up to what stage time can be given? One of the creditors, Sohan, who had filed a claim of 50 lakhs, he expired due to COVID. Suppose there is a creditor who expires due to COVID, then who will be entitled to claim on his behalf? Akbar's sister lives in London. Now Akbar is one of the partners and her marriage is fixed on 7th July. So whether he can travel overseas during bankruptcy, we have recently seen in the other case study also that during insolvency there is no such restriction, but during bankruptcy there is. Next point is, since the BT was not well versed with the functioning of the cinema hall, he appointed Anthony to supervise the management of the cinema hall. Now, in this case, the management is being entrusted to one of the partners. So whether during bankruptcy proceedings, we can take help of the management, we can take help of the partners. This is another point. Or whether we have to keep the partners out. This is the question here. On examination of books, it was revealed that one of the properties belonging to the firm had been transferred to the daughter of wife of Akbar at market value. Now, daughter of wife of Akbar means daughter of Akbar. I know, because daughter of wife of Akbar or daughter of Akbar is one and the same thing. So whether during bankruptcy, you can transfer the property to daughter, whether a partner can transfer the property to daughter, although at market value, or it is prohibited at all. So this is the question. The transaction is being done at market value, but whether it can be done or not, that is the point. Or whether it will be presumed that it is a PUFE transaction and we don't have to see any other thing. This is the question here. So while bankruptcy proceedings were going on, Anthony expired. Now one of the partners is expired because there are three partners, Amar, Akbar and Anthony. Now Anthony is expired. And his legal representative had claimed a sum of rupees 1 lakh towards funeral and testamentary expenses. So in case a partner expires, whether his legal representative can claim this funeral and testamentary expenses, this is another point. One of the employees of Amakan and Company who had dues of 20 lakhs is presently serving in Dubai. Now, one of the employees, he has already left the firm. He is unable to come to India, but his dues are properly reflected in the books. So whether on the basis of reflection in the books alone, the bankruptcy trustee can account for such debts, or whether he has to file a claim. What is the provision regarding this? So these are some of the questions to which we will be seeking answers. You can answer in the group, or you can answer. We'll frame questions tomorrow on this, and we'll continue with this case study. Let us see another case study in the meantime. Now it is clear, hai, Tavinder Pal Singh ji?
Yes, sir. Clear, sir. Nice.
Hai na? How? So I have framed a question on almost each and every section, each and every provision. And if you want to again know the questions, you can always watch the recording. So based on recording, you can note down the questions and then you can answer. You can answer in the group also before tomorrow. Just a minute.